January 1st, 1900. New century, new empire, new civil code. The BGB finally comes into force across Germany. After decades of drafting, arguing, revising, and probably enough footnotes to sink a ship, private law is now unified. And that makes today a pretty good day to ask, what kind of legal mind actually won?
It is indeed a decisive moment. The Bürgerliches Gesetzbuch is not merely a statute book. It is the result of a long scientific effort to order private law with precision, coherence, and conceptual discipline.
Yes, but already one hears the danger in that description. Scientific effort, conceptual discipline. Very elegant, certainly. But law is not only a machine of concepts. It lives in social bodies, in associations, in communities, in real relations between persons.
And there we go. We are about 30 seconds in, and the gloves are already on the table. So let's place the camps clearly. Bernhard Windscheid stands for the pandectist side of things. Roman law, system, abstraction, clean categories. Otto von Gierke comes from the Germanist side, more skeptical of legal thinking that floats too far above actual social life.
That is fair, though I would put it less dramatically. The pandectists did not wish to escape reality. They wished to make law intelligible. Without clear concepts, one cannot decide cases consistently.
And I would say, without attention to collective life, one cannot understand what law is for. The Germanist critique was never only emotional or national romanticism, as some imply. It was a protest against excessive abstraction.
Right. So, big picture, both of you come out of the long shadow of the historical school. That school said law is not just invented overnight by legislators. It grows historically, it develops, it belongs to a people. Which sounds nice and organic until everyone starts fighting over what that actually means.
The historical school was crucial because it rejected arbitrary codification detached from legal development. Law had to be studied historically and scientifically. That insight matters enormously for the BGB.
But from that common starting point, the paths separated. The pandectists turned strongly toward Roman law and toward highly refined juristic construction. The Germanists looked more to specifically German legal traditions and to social forms not well captured by purely individualistic categories.
So same family tree, very different personalities. One branch says, let's build a polished legal system. The other says, fine, but do not forget the people actually living under it.
The BGB, if we are honest, bears unmistakably the mark of pandectist method. It is structured, abstract, and systematic. That was not an accident. It was an achievement.
An achievement, yes, but also a narrowing. The final code reflects a victory of juristic technique. Whether it reflects social reality equally well, that is another question.
And that's the tension for the whole episode. The BGB arrives as a triumph of legal unity. But inside that triumph sits an older argument. Is law best understood as a rigorous science of concepts or as an expression of lived social order? To answer that, we have to go back a bit, to Savigny, Thibault, and the fight that set the terms in the first place. So let's rewind. Before the BGB ever became real, there was the famous dispute between Thibault and Savigny. Thibault wanted codification sooner, a clear national civil code. Savigny pushed back, not because he hated order, obviously, more because he thought law could not just be manufactured on command.
Precisely. For Savigny, law grows from the historical life of a people, the Volksgeist. That term is often simplified, but the point is serious. Law is not merely legislation. It arises historically and must be understood through learned interpretation.
Yes, but we should not let Volksgeist become too mystical. In practice, Savigny's position gave enormous authority to jurists. The people appear, certainly, but through scholarship, through doctrine, through interpretation, not directly through political will.
Which is kind of the twist, right? Spirit of the people sounds democratic for about 5 minutes. And then suddenly you are in a room with professors and Roman law texts.
That is a witty exaggeration, but not entirely unfair. Still, Savigny's turn to Roman law had a clear reason. Roman law provided a highly developed legal vocabulary and structure. It made possible a serious legal science.
And there is the issue. Legal science, yes, but science of what kind? The more the tradition developed, the more private law became organized around abstract persons, rights, transactions. This reaches its mature form in the BGB, especially in the general part.
Let's pause there, because that matters. The general part is one of those things legal scholars say very calmly, while everyone else quietly wonders what planet they're on. But it's important. It means the code begins with very general concepts, persons, legal acts, time periods, that whole framework, before getting to specific areas.
Exactly. It is a hallmark of systematic thought. Instead of repeating basic concepts in every field, the code states them once in a general, refined form. This creates coherence and technical clarity.
And also distance. The general part is brilliant in construction, but it reveals the dominance of abstract jurisprudence. Social relations appear filtered through categories that can miss the reality of groups, associations, and unequal power.
So now we get to the verdict question. Who won? Thibault wanted codification. Germany got codification. Savigny resisted immediate codification. And yet somehow this still ends up looking like a win for Savigny.
Yes, not politically perhaps in the simple sense. The code did come. But the manner in which it came, its structure, method, and conceptual architecture reflects Savigny's legacy. Legal science shaped the code more deeply than political impatience did.
I would agree, though not as praise without reserve. Savigny wins because jurisprudence wins. The jurists win. The scientific style of law wins. Whether society wins to the same degree, I remain less certain.
That's probably the cleanest way to put it. Final judgment? Savigny wins through legal science, not politics. The BGB is the monument to that victory. Brilliant, durable, and, depending on where you sit, a little too far above the street. We'll leave it there for today. Otto von Gierke, Bernhard Windscheid, thank you both.
Thank you. It was a pleasure.
Yes, thank you. Until next time.
And thanks for listening. We'll be back soon with more legal history, because apparently the past never really stops arguing. Goodbye.